Our second case on the docket this morning is State of Kansas versus James Edwin Speer, number 129053. Counsel, will you please enter your appearances?
May it please the court, Mr. Speer, appellant, here's for counsel, Chris Joseph.
The people in the state of Kansas, Ethan Speer.
Thank you. And counsel reserving
I'll take 3 minutes.
3 minutes. You've got it. You may proceed.
Mr. Speer appeals the denial of his motion for new trial based on newly discovered evidence, that is the testimony of James Speer, Sherry, I think is how you pronounce it. I'm going to go with Sherry, that if believed would exonerate him. The district court determined it wasn't material, didn't make findings of fact, but determined it wasn't material. That analysis is flawed. This court must review the materiality issue de novo, and if it is material, determine whether or not a reasonable person.
Isn't this an interesting case where it was tried to the court?
It is, yes.
And it was then considered by the judge whether or not it would have made any decision in his previous ultimate finding of guilt?
It is. Now,
I mean, generally we're dealing with this question for jury.
correct. No, I recognize it. It is unique that way. I don't think it changes the analysis though of determining materiality. Now that also jumps to the fact that the district court made all sorts of mistakes of fact in his analysis, both at the conclusion of the trial and mistakes of fact when he's analyzing this new trial. There are fundamental problems with the district court's ruling. District court said, hey, whether or not the crime happened itself is in contention. It absolutely was. The young lady said, in 2013, she reported something that wasn't a crime. 7 years later, she changes the story dramatically. She tells the forensic interviewer, hey, I'm not even sure if this is real. I thought it was a dream at first. She identifies somebody else, walks that back, says later, hey, after mom says falsely that Mr. Speer is in prison for molesting a 2-year-old at the same party, says, oh yeah, that's him, panic attack, doesn't identify the person in court, doesn't identify the person in a photo lineup. I mean, the evidence is super thin. The district court makes mistakes of fact in his analysis, both at the conviction and incorporating that in the motion for new trial, saying, hey, there was an in-court identification. I mean, it's a terrible record. I mean, the court's analysis is terrible. He was there. He did hear everything.
Well, I mean, I thought the young lady said he looks different.
Yeah, so the question was...
She didn't identify him. She said he looked different.
So the in-court identification is kind of, I admit it was kind of an awkward question. It says, it's the person, I have it here somewhere. Does the defendant that sits here today, does he appear to be the same man that touched you at the house? The answer is no.
Right, but then it's qualified, right? Later.
No, that's the extent of the testimony.
Well, the state then says what's different, and the victim says his hair. The state questions, so when this happened, he had hair, and then she responds, and he was skinnier. So just saying no, I mean, isn't that sort of a...
Well, yeah, it's not. Yeah.
That's omitting the part where she actually, yeah, he looks different.
I would agree with you if she says that guy had more hair, that guy was skinnier. It's not.
But isn't that
no, that's not what she
clear, right?
said. She said the person had more hair, and add that combined with when you look at a photo lineup, a 6-pack. She doesn't pick him out, says he's not there. I mean, like, she's repeatedly not identifying this guy. She does identify Smith, who she says, I thought it was him until mom told me about this other guy. And then she has that big emotional reaction. So, I mean, that's 7 years later. You go back to 2013 when this thing first happened, it was only that somebody touched her on the hip. So, I mean, this is, I've tried a lot of cases. This is thin in terms of evidence. The alibi defense wasn't great. I'll give you that. That's a strange choice. The bench trial, perhaps a strange choice, but this evidence is thin. It's 7 years later, completely different version. The circumstances which it's presented to her to identify this man are highly suggestive. It is a thin case. And so you have after this new evidence, Mr. Sherry come forward that if believed it's the same party, Speer stayed in Sherry's line of sight throughout the party until 4 a.m. when Speer left with Smith. That's exonerating,
But
right?
didn't Sherry also testify that he wasn't sure if the party he was at was the same one where this victim claimed she was assaulted, or if there had been other parties?
So he did
Definitive.
acknowledge, so he's, after the trial, the detective goes and interviews him, and I think Sherry's description was like he injected some doubt as to whether or not this was the right party. It could have been a different party. And he acknowledges, honestly, like, yeah, I don't know. The problem with that, though, is the record. There's only one party where the kids are, just one, right? So if you look at volume 914, the state is summarizing, that's page 14 of volume 9, the state is summarizing that Alexis only went to the pink house once. And then if you look at volume 10 at 35, report admitted to the record, Kirkwood said he was fairly confident there was only one party where Davenport's children were present. So while there could have been multiple parties, and I suspect there were multiple parties at this pink house over that summer, there's only one where the kids were present. So you have a sober man who has a different memory than drunk people. The sober man remembers some things the drunk people doesn't remember. But again, there's only one party where the kids are present this whole summer. That cuts against the idea of, he's talking about a different party with the kids. There's only one party. The state even says so in its closing argument. So, the fact that Hannah says, hey, James Speer usually wore tan cargo pants and a black jacket. That's not enough to say, hey, materiality is gone. Because remember, these are not findings of fact by the district court when you rule it. District court is saying, hey, materiality is limited because he might be talking about a different party.
Are you not asking us, though, to reassess witness credibility? I mean,
No.
it ultimately, isn't that what the district court did? The district
didn't.
court heard all of these witnesses, heard this new witness and said, it wouldn't change my mind.
He said it wouldn't change my mind, but he didn't say based on credibility. If you look at the ruling, and I've read this a bunch of times, trying to make sure that that wasn't the issue, because it would be fatal if it was. I agree. If he says he's not credible, that's fatal. We're dead. So I'm looking at back on volume 5, page 30 and 31. The district court is saying, hey, there's some conflict with these other folks' testimony. Therefore, he might have been talking about, perhaps he was talking about a different party, which minimizes the materiality of the value of that testimony. That's ultimately what he holds. He doesn't say not credible. In fact, he says, I believe he's being truthful. He doesn't say I'm making a finding, a credibility weight. He's not making a finding of fact. He's saying perhaps he's talking about a different party, which minimizes the materiality and the value of that testimony. So it is strictly a weighing the materiality, strictly that, which you look at de novo. You can completely disagree with that. That is a de novo analysis. And when you look at that de novo, if you look at his analysis of, hey, it could have been a different party, there's different memories as to what happened. That's what makes it so material, right? The two, Hannah and I think Sandra think they saw him in the house. Sherry said he never left the line of sight. He was outside the whole time. That's the issue, right? That's why it is material. That's not probably a different party. There is only one party. Very different memories, very material. And so no, if it was, I agree with you. If he said, I find Mr. Sherry not credible, or if I find that, make a finding of fact, we'd have something different. But again, I invite you to reread that page 30, 31 analysis. Perhaps he's talking about a different party that minimizes the materiality and the value of that testimony. And again, you're doing de novo review of materiality. there are also a series of mistaken facts and mistaken law in here, and I don't want to get too much, I have very little time left, so I'm not going to get into the specific mistaken facts, but I will point out a few of the things. The judge starts with the premise that, hey, he presented an alibi, ergo it's conceded that this happened, that there was a sex crime. That is not the case. When you have an alibi, that doesn't mean the state is relieved of its burden to prove the event actually happened. In fact, there's a whole lot of reasons to believe that this may not have happened. Specifically in 2013, it didn't happen. 7 years later, under these highly suggestive, suspicious circumstances of, are you gay because you were molested at some point? Yes, mom, I was. Picks the wrong guy, changes it to Mr. Speer under suggestion. That is controversial. There's all sorts of reasons to think it may not have happened. And if you believe Mr. Sherry, it probably didn't happen, or it was somebody else. That a jury or judge, depending on how the retrial goes, has to be factored in. It is extremely material. As to the mistakes of law, there is that issue about this perjury or admissible as a prior inconsistent statement. That assumes that when at a retrial, he's going to testify, and he's going to testify the same way. I don't know if I'm going to retry this case and he listens to me. My hunch is he probably doesn't testify, and we probably just go with James Sherry and throw out all this fact and let a jury decide whether or not they've proven beyond a reasonable doubt that it happened and that he was the one that did it, because that is a really tough question to come to beyond a reasonable doubt if you consider James Sherry's testimony.
Anything further? All right, thank you, counsel. You still have your rebuttal.
Thank you.
For the state?
Your Honor. I do a lot of appeals, and it's unusual that I get to argue this, so I'm going to have fun. I believe the defense has misstated the standard of review. The standard of review is purely abuse of discretion. In 2024, we have the James case, and the state and the Kansas Supreme Court says without qualification that the standard of review on a motion for new trial is abuse of discretion. And I believe the Brown decision on Friday heavily supports that this is now the standard of review. On Friday, the Kansas Supreme Court said in no uncertain terms, we were not there. We did not watch the evidence. We did not watch the trial. So questions about the impact of evidence on the trial are purely within the discretion of the district court. And that decision came out a few days ago. So I think it is clear the standard of review is abuse of discretion, period, not de novo. And once we get into abuse of discretion, every piece of Kansas law tells us that this court owes deference to the finder of fact. If there's ambiguity in testimony, we resolve that in favor of the finder of fact. If there's an interpretation of the evidence that supports the finder of fact, we move to the finder of fact. The standard of review in this case is abuse of discretion, period. And that's the state's argument. It is not de novo. Now, moving on to a couple other things. First, I take great issue with misrepresentation of parts of the evidence. The defense counsel says there's only one party at which there were children. That is not what the evidence shows. There was only one party the victims were at. And this is important because Sherry even testifies that initially he wasn't sure which children they were talking about. He thought it was the homeowner's children, not the victims. So this testimony from Sherry is inconsistent all the way around. So the district court hears this testimony and comes to a conclusion. Do I think if I had heard this testimony at the time of the trial, it would have changed my verdict? And the answer is no. And the district court is the finder of fact. So there's no way for any of us in this room to say, yes, the district court's opinion on that matter is wrong.
Well, you point to an interesting anomaly that we have in this particular case. I would think that it would be different if this was tried to a jury.
But it wasn't.
It wasn't, and so are we to look at it differently?
Yes, absolutely. Everything in Kansas case law tells us that we give deference to the finder of fact. And in this case, the finder of fact is telling us what they thought. And I'm going to get into this in a minute because I think it affects another question, which is what's the remedy if there is a problem? And I think that's the other issue, which is if there is a problem with this, and there is one fact that the district court said, and I don't think it impacts this for other reasons, but that certain evidence was incontroverted, and it had to do with the order of who left the party. The district court said that was uncontroverted. There was actually different testimony about when those witnesses left. It's the only thing I'm going to say that the district court got categorically wrong. But there's two issues with this. One, under abuse of discretion, the district court can be affirmed if they are right, albeit for the wrong reasons. So that is harmlessness. You have to decide, does the order of which the parties left matter? Second issue is that was a trial finding, not a finding at the time of the hearing, and the defense cannot get up here and challenge the trial findings right now. One, they never preserved that. They never objected to the trial findings. They never asked for motion to reconsider. And so they are bringing that for the first time on appeal. They have not outlined a single exception to the first time on appeal doctrine, which they are required to do. And if they aren't doing that, the only possible way to challenge the district court's findings for the first time on appeal on the jury trial is a sufficiency of the evidence claim, which they haven't raised and which still requires deference to the remaining findings. It doesn't matter if the district court said something that was wrong on the record. All that matters is that the verdict is supported by sufficient evidence. So I'm sorry, but you cannot try to backdoor a challenge to what the district court said at the time of verdict by going to the motion for new trial. There's nothing that allows that exception. They haven't given you any exceptions for raising it for the first time on appeal. It's not properly before this panel. So all we go is the one factual statement that they are pointing to that they say is incorrect from the time of the actual motion for new trial, and that was whether or not what clothes he was wearing. And it is a reasonable interpretation of the evidence from the statement that the police asked one of the witnesses, what was he wearing? And the witness says he usually wears, I believe it was jeans and a dark jacket. A reasonable interpretation of that evidence by a finder of fact is that's what he was wearing that night, because that's how she's responding to the question, what was he wearing that night? And when things have multiple interpretations, we defer to the finder of fact. So
I probably shouldn't ask this question, but I will anyway. If I'm intrigued by the fact it was tried to the court, did I miss something in the record as to the rationale for that decision and not to a jury?
I don't know. I don't see anything on the record.
Okay, I just want to make sure I didn't miss something, because I just am intrigued that this big of a factual question was tried to the court instead of a jury of 12.
I don't know why. But also, I mean, the defense has said that if it goes back, it will be tried in front of a jury. That is not true. Once you waive your right to a jury trial, and you've waived your right to a jury trial, there's no argument anywhere in the record that that was not knowing and voluntarily done. He's already waived his right. Even if it was reversed, it would go back with him already having waived his right to a jury trial.
Yeah, but the court could grant it back. It's a discretionary call.
It's a discretionary call, but that's not a guarantee. And also, again, the district court was at the question in a motion for new trial boils down to this. Is the new evidence so material that it would have changed the verdict? The district court is uniquely in the only position to say that, because the district court is both the juror and the finder at the motion. So
That's the anomaly of
it is,
case.
but the final conclusion of this is the district court knows for certain if Sherry's evidence would have changed his verdict.
And your argument is we have to determine that's an abuse of discretion.
Correct.
And it's the trial court's unique discretion,
Correct.
because the trial court is the finder of fact, the determiner of guilt.
Correct.
So it is an anomaly. And the old standard, I mean, we'd have to be convinced by much more evidence than by this standard.
True.
Yeah.
I also do not believe that Sherry's testimony, that even under a de novo standard, you can say that that would have changed anything, because it's clear that he wasn't at the party. Multiple witnesses from that night contradict his testimony about Speer being allowed in the house. And he even admits there were multiple parties at the house. He initially was confused about the children and what they were. The most reasonable conclusion from the evidence is that Sherry was not at the party where the abuse happened. And once you get to that conclusion, none of his testimony matters. His testimony is anomalous with literally every other witness who testifies. And he says there were multiple parties at the house and that he was originally confused about which children he was talking about. So it is pretty much night and day. If you come to the conclusion that he wasn't at the house, then his testimony doesn't add anything to the jury trial. And then I just want to touch finally on the issue of contradictory defenses. Again, I think the defense has way misinterpreted what the district court said. The district court at no point ever said you are not allowed to put on contradictory offenses. Nowhere in the record does the district court say that. The district court says these defenses contradict, this person's testimony contradicts what you said on the record. And that is a factor in whether it would have changed the outcome of the trial. If you put a witness on that is going to completely undermine your own testimony, it shreds your credibility or it shreds his credibility. Either way, the conclusion is it would not have changed my verdict. So that's not a mistake of law. There is no statement. And also the contradictory defenses, and I cite to this, it only applies to what jury instructions we give. You are entitled to jury instructions on contradictory defenses. That is the extent of what that law says, and it has nothing to do with this case. So it's just not a factor we should be considering. I just want to, again, touch on the last part where, and I just want to hit home on this. On remedy, the proper remedy in this case, if this court finds it was an abuse of discretion because of a misstatement of fact or law, is to remand for the district court to redo the decision and issue an opinion without the mistake of fact considered. That is the proper remedy. So if this court is inclined to say that a mistake of fact caused the court to abuse its discretion, this court should remand specifically for the court to reconsider the motion for new trial without consideration of the mistaken fact. That would be the proper remedy here, not granting a new trial. So that's the final point I would say, and that's something I really want to hammer home. And if there are no further questions,
I don't.
see. Thank you.
Counsel. You have your rebuttal. Just a second, we'll get it set up to 3. There you go.
So the standard of review is not misstated. It is frequent. It was throughout Kansas Supreme Court case law. We review a district court's decision for new trial for abuse of discretion. We review materiality de novo, giving deference to the district court's finding. That's Rojas Marcelino. There's Haddock v. State that says the same thing. You look at it de novo and then determine whether or not a reasonable person would conclude that it would change the outcome.
Counsel, are you familiar with this Brown case that your opponent mentioned that was handed down Friday?
No, to be candid, I'm not. So if they've changed the standard of review on Friday, that's a problem. So
Is that something that you would like to, in a rule letter?
Yeah, it's not a motion for new trial. It's on motions for mistrial and the split opinion.
Okay,
Brown is, but I think it's applicable.
all right. Thank you.
setting aside Brown, which I honestly didn't see and don't know that that changes standard review, but if the standard review is what it's been for, 20 some years, it also doesn't matter whether or not it's a judge trial or a jury trial for the standard that you review materiality de novo and then determine whether or not a reasonable person would agree with the district court on that. That's the standard. And it doesn't matter whether it's a bench trial or a jury trial. And in this case, I think materiality is the winner. I do also think there's mistakes of law and fact. I think those things go hand in hand.
What about counsel's argument that there was only one party where this child was present, but there were other parties with children present?
It's not what the record says. So the records, I agree with him that I did not say, and I don't think I meant to say, if somebody heard that the record was there was never a party with children. The record is void on that. The only thing the record says is reference to children is that these children were only at one party, that Justin JD brought his children to one party, this party. Now, the record is silent as to whether or not there's other parties with children. I mean, is that a theoretical possibility? I mean, sure, but there's nothing in the record one way or the other. You know, Mr. Sherry seems to remember this guy's kids being there. So there's one party in my view.
All right. All right, thank you, counsel. We'll take this under advisement, issue a decision as soon as we get to it.